Guys, it's Mo from Mo in the Deep End, and we have some new movement, actually a flurry of movement in the Richard Allen or Delphi case. And the first one I wanted to cover with you is that the newly reinstated Bradley A. Rossi and Andrew J. Baldwin are again asking that Judge Gull be removed. This was filed with the Carroll Circuit Court, on the 28th at 10 p.m. So, State of Indiana, Carroll County, versus Richard Allen. Affidavit of Richard Allen. Now comes affiant Richard Allen and swears and affirms the following statements and reasons for disqualification are true and accurate, as I have either personal knowledge or have learned of these facts and reasons through my counsel, Bradley A. Rossi and Andrew J. Baldwin. 1. Judge Gull interfered with Richard Allen's attorney-client relationship. On October 12, 2023, Judge Gull instructed appointed counsel to, quote, cease work on Mr. Allen's case, with a number 1 footnote we will get to at the end, which interfered with the attorney-client relationship and prejudiced the accused by denying him timely, effective representation guaranteed to him by the state and federal constitutions. This disarming of counsel also occurred immediately in advance of Judge Gull ordering up a hearing in her own courtroom in Allen County, Indiana. At the hearing, Judge Gull stated the premeditated removal of attorneys Rossi and Baldwin, complete with cameras in the courtroom for the first time ever in this case, with Gull having prepared in advance a handwritten statement which claims the grossly negligent and grossly incompetent actions on the part of each lawyer. The footnote is, this directive by Judge Gull was included in an email dated October 12, 2023, 11:03 or 02 a.m. from Judge Gull to attorneys Rossi, Baldwin, and prosecutor McClelland. 2. Judge Gull publicly and on record disparaged defendant Allen's chosen attorney. The week before October 19, 2023 hearing, Rossi and Baldwin had asked Judge Gull what to expect in said hearing. Rossi and Baldwin knew from an October 10, 2023 phone call that Judge Gull had commented that she was inclined to have Rossi and Baldwin removed from the case at the request of prosecutor McClelland before any hearing had taken place, before researching the issue or even having any meaningful chance to consider the request. Between October 10th phone call and October 19th hearing date, Judge Gull prepared a scripted statement that would otherwise be used as her basis for finding that Rossi and Baldwin acted grossly negligent and with gross incompetence in their duty as defendant Allen's lawyers. It should be noted that Judge Gull later added to her list of allegations that attorney Rossi and Baldwin also violated the rules of professional conduct, and there's also a footnote too. There exists a rational inference of basis or prejudice because Judge Gull formed these opinions. Worse yet, Judge Gull claiming on record in chambers that she is finding gross incompetence on the part of Baldwin and Rossi provides a rational inference of basis and prejudice. A judge that has predetermined an attorney is grossly negligent and grossly incompetent has developed a bias toward that attorney. The mere reference to Rossi and Baldwin being incompetent would be strong evidence of a rational inference of bias and prejudice. And 2, it's see page 12 of Respondent's Brief in opposition to Realtor's verified petition of writ for mandamus in cause number 23S OR 311. It is noteworthy that Judge Gull makes these claims despite her own appellate attorney acknowledging to the Indiana Supreme Court that attorneys Rossi and Baldwin were, quote, very experienced and highly competent lawyers in all other respects except for their alleged incompetence and grossly negligence acts in this case. Contrasting facts are hard to reconcile. Ooh, bring the smoke, men. Bring the smoke. claiming that she, Judge Gull, finds them grossly incompetent, provides even more conclusive evidence of rational inference of bias and prejudice. Judge Gull telling Rick Allen that she has grave concerns, footnote 3, about Baldwin and Rossi representing him, provides a rational inference of bias and prejudice. And finally, Judge Gull, for the first time ever, allowing cameras into the courtroom, knowing her plans to ambush the defense and how cameras in the courtroom would impact the attorneys psychologically as they try to process their options, provides a rational inference of bias and prejudice. Number 3, Judge Gull violated defendant Allen's due process rights. On October 19th, 2023, Judge Gull ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming at the expense of Richard Allen and be removed from the case, or to voluntarily withdraw in the face of compromising Rick Allen's defense strategy. Despite defense counsel requesting clarification as to the topics and/or motions to be addressed at the October 19th, 2023 hearing, Judge Gull gave the defense counsel no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. Judge Gull's failure to offer up to the defendant or his counsel the basic process of the law creates a rational inference of bias or prejudice toward he and his attorneys. That same day, Judge Gull had prepared a statement that she threatened to read to the public, alleging defense counsel was grossly negligent and incompetent in their representation of defendant Allen. Judge Gull's complaint was more about not having, and then the footnote 3, Judge Gull spoke these words to Richard Allen at the October 31st, 2023 hearing in Carroll County Circuit Courtroom. So she told Richard Allen on Halloween that she was gravely worried about him trying to keep his original defense team. Was more about not having control over counsel rather than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defense. In support of Judge Gull's forced removal of attorneys Rossi and Baldwin, Judge Gull cited a number of different concerns, none of which formed a basis for their removal under Indiana law. Additionally, until in chambers hearings, other than the topic of the evidence leak, Judge Gull had never underlined before mentioned to counsel that other items she mentioned in chambers were worthy of them being disqualified from the case. There is no way that the defense could have been prepared to refute or argue, for example, Judge Gull's apparent belief that Bradley Rossi's filing of a tort claim notice to protect his client's right was one reason that she, Judge Gull, thought the defense should be disqualified. Judge Gull provided no preview of the topics she intended to discuss, which caused her to disqualify Allen's attorneys, other than the leak, and certainly never told the defense that she had already made up her mind to remove them from the case. In other words, the majority of the topics Judge Gull raised with the defense as reasons for their removal at the in-chambers hearing were complete surprise to the defense. What happened in chambers was a violation of Richard Allen's and his attorney's due process rights. Accordingly, the Indiana Supreme Court recently ruled that Judge Gull's actions in removing Baldwin and Rossi were in error and reinstated attorneys Rossi and Baldwin as Richard Allen's appointed public defenders. This reversal of Judge Gull's removal of Baldwin and Rossi and refusal to accept their appearances as pro bono lawyers took place very publicly over a course of tense litigation, pitting Judge Gull on one side and Bradley and Rossi, though their clients' original action against Judge Gull, through their client's original action against Judge Gull, on the other. Judge Gull chose to retain counsel to fight the original action. The highly public and contentious litigation between Judge Gull and Rick Allen, and therefore between Judge Gull and the attorneys Baldwin and Rossi, provides rational inference of bias and prejudice. 4. Judge Gull engaged in critical stage proceedings in defendant's absence. On October 19th, 2023, Judge Gull conducted critical stage proceedings in chambers outside the presence of the accused, even though she had ordered him transported and he was available to participate in the in-chambers hearing, placing his attorneys in an ethical dilemma and creating a public record outside the presence of the accused. This ignored any sense of due process and violated Rules 1.2 and 2.2 of the CGC. 5. Judge Gull failed to maintain impartiality and fairness. Judge Gull engaged in a planned, forced resignation of the defense team in her chambers on October 19, 2023. Judge Gull again referenced defense counsel's pleadings that contained in her words, quote, inaccuracies and falsehoods, end quote. The court's references were connected to facts and circumstances surrounding the emergency motion to modify the safekeeping order that was denied by the court on the same day the court instructed IDOC staff to stand down on the transport of a subpoenaed defense witness. The court's own action were and are prejudicial to the defense to defendant Allen's defense. Judge Gull's belief that counsel would provide false pleadings to the court, thereby questioning their integrity, exhibits a rational inference of bias and prejudice. 6. Judge Gull demonstrated bias toward the prosecution. In the days leading up to October 19, 2023, hearing in Fort Wayne, Judge Gull, attorneys Baldwin and Rossi, and Prosecutor McLeland participated in a phone conference to discuss matters associated with the dissemination of crime scene photos. It was during this phone conference that Prosecutor McLeland first uttered the word disqualification. After a very brief discussion, Judge Gull communicated to the parties that she, at the moment, was inclined to grant the request. The comments were made by the court without having conducted even the most informal of hearings, without having considered any single piece of evidence. Without consulting with defendant Allen on the matter, Judge Gull's conduct of quickly siding with the prosecution on an off-record phone call on a matter of such high importance, i.e., illegally kicking off lawyers who have spent thousands of hours on the case, would be prepared for a January 2024 trial date, demonstrates a rational inference of bias against defendant Allen and runs afoul of Rule 2.3 of the CJC. 7. Judge Gull made public misrepresentations on the record. Immediately following the court's planned removal of the defense team, Judge Gull took the bench and addressed all those in attendance as well as the public at large. Through the lens of a pool camera authorized by Judge Gull, broadcasting the proceedings to the general public and potential jury pool, in a pertinent part, Judge Gull spoke the following words. We've had an unexpected turn of events, ladies and gentlemen. Earlier this afternoon, the defense attorneys have withdrawn their representation of Mr. Allen. The court concluded the hearings by saying, clearly this is outside of our control. When referring to the events that took place in chambers, these words spoken are untruths as the withdrawals of Baldwin and Rossi are exactly what Judge Gull had pre-planned to happen. Her words to the public, therefore, appear to have been intended to disguise her in-chamber actions which forced their resignation, and Judge Gull knew her actions were wrong, as later she tried to conceal what happened in chambers. When Richard Allen's original action lawyers attempted to obtain a transcript of in-chambers hearing, Judge Gull's staff refused to access the transcript, calling it, quote, confidential, end quote. Richard Allen was therefore denied his right to a transcript of the hearing wherein he was not present and wherein his lawyers were effectively severed from him without his consent. In order to review what happened in chambers on October 19, 2023, Rick Allen's counsel on the original action were forced to request the Indiana Supreme Court to order Judge Gull to release the transcript. Allen's counsel made this request on November 6, 2023. On November 8, 2023, the Supreme Court ordered Judge Gull to release the transcript. Ultimately, Judge Gull complied. Judge Gull's attempt to deny Allen's lawyers the transcript of the in-chamber hearing and to keep the transcript hidden from Allen's attorneys and from the public provides a rational inference of the bias against Richard Allen and his defense team. The court's own word to the public on October 19, 2023, hearing claimed that the events were unexpected and were out of the control of the court, are in conflict with Rule 1.2 of the CJC and support recusal pursuant to Rule 1 or 2.11 of the CJC. 8. Judge Gull engaged in ex parte communications. On October 30th, 2023, attorneys Rossi and Baldwin filed their private appearances on behalf of defendant Allen as his pro bono attorneys. I only speak English, and sometimes I can barely do that. The next morning, attorneys Baldwin and Rossi appeared in person in the Carroll County Circuit Court as defendant Allen's pro bono attorneys with ethical and legal duty to carry out their representation of defendant Allen. However, Judge Gull, with intentionality, refused to allow attorney Rossi and attorney Baldwin to carry out the representation of the client. This included communicating by text to Judge Gull's chosen replacement attorneys, Robert Scremin and William Libretto, prior to the start of the hearing. This also included engaging with in-chambers conference with said replacement attorneys and prosecutor McLeland while attorneys Rossi and Baldwin remained in the courtroom with their client. After taking the bench, Judge Gull, on her own volition, severed the attorney-client relationship for the second time without seeking the opinion or permission of Richard Allen, the client. This sua sponte severance of the attorney-client relationship without the input or permission of Mr. Allen was prejudicial to his defense. The court's actions were not only violative of defendant Allen's rights, but significantly impair any public transparency in the actions of the judiciary. 9. Judge Gull denied defendant Allen his Sixth Amendment right to counsel and in doing so his right to a speedy trial. Judge Gull denied defendant Allen his Sixth Amendment right to counsel when she forced their resignation during the October 9th in-chambers hearing. Rossi and Baldwin then entered their appearances as private counsel for Richard Allen. This was done at Richard Allen's request. Richard Allen's intentions were to file a speedy trial motion and secure his previously scheduled trial date of January 8, 2024. Judge Gull prevented this from happening by refusing defendant Allen of the attorneys of his choosing. Judge Gull's refusal to allow defendant Allen's counsel of choice back onto the case effectively derailed any strategy defendant Allen and his lawyers had developed in an effort to move his case into a courtroom and challenge the merits of the state's charging information. The judge's actions were per se prejudicial to the defendant Allen in that he was denied of his basic constitutional right of choice of counsel and also his basic constitutional right to a speedy trial. By extension, the denial of his right to the January 2024 trial date was prejudicial to defendant Allen because he was returned to, quote, safekeeping, end quote, within the confines of the same maximum security unit wherein he was unfairly detained and experienced both mental and physical deterioration for nearly a year prior to Judge Gull's Sixth Amendment violation. 10. Judge Gull changed her ruling in a prior order when attorneys Rossi and Baldwin were reinstated. Judge Gull received the Franks memorandum on September 18, 2023. She took no action on the Franks filing for over 4 months. She did, however, offer her chosen public defenders the opportunity for a hearing while they were representing Richard Allen. This is evident from her November 1st order, wherein she offered up the following invitation. Quote, court notes 2 pending motions, motion to suppress, motion for Frank's hearing, and will await a report from attorneys Scremin and Librato and prosecuting attorney McLeland regarding hearing dates. The court then memorialized this invitation to pursue these motions in a minutes entry reflected on the CCS on November 2nd. Then again on November 14th, the court issued an additional minutes entry then, inviting defendant Allen's new counsel to set a hearing on the pleadings. The minute entry marks as follows. If the defendant's new counsel informs the court they intend to pursue the Frank's motion, the court will, underline in bold, schedule a hearing, emphasis added. So obviously they didn't bold and underline in the hearing thing. 2 business days after attorneys Rossi and Baldwin were reinstated, Judge Gull issued an order denying a hearing on the Frank's motion and denying a motion in limine filed by Rossi and Baldwin regarding the admission of ballistic evidence by the state, which appears to the defense to be a hastily written opinion, lacks any serious legal and factual analysis on such an important issue. The absence of any real factual or legal analysis contained in Judge Gull's orders begs the question of whether Judge Gull actually engaged in any meaningful review of the memo and attached exhibits. The timing of the ruling and the lack of serious legal and factual analysis provides a reasonable and rational inference of bias or prejudice against Richard Allen, and most notably, Judge Gull offering her chosen replacement attorneys the opportunity for a hearing on the pleading motions while denying Baldwin and Rossi the same opportunity creates a rational inference of personal bias against Richard Allen and his current defense team. 11. Judge Gull discredited defendant Allen's defense strategy. On November 14th, 2023, Judge Gull issued an order that in pertinent part acknowledged defendant Allen's filing of a motion for a Frank's hearing, memorandum in support, and accompanying documentation. These documentations had been filed by defendant Allen on or about September 18th, 2023. Nearly 2 months later, Judge Gull, having taken no action on defendant Allen's pleading, invited successor counsel to either adopt those pleadings or make their own. Implicit within Judge Gull's verbiage is what appears to be the court's attempt to empower her chosen replacements, attorneys Scremin and Librato, to abandon a material aspect of Allen's defense strategy. If there is any debate about the court's intention, at the very least, Judge Gull's order and the language therein creates the impression that the court is skeptical of Allen's defense strategy, thereby prejudicing the totality of his defense. Accordingly, Judge Gull violated Rule 2.3 of the CJC. Number 12. Judge Gull committed violations of the Access to Court Records Act. Judge Gull did remove and seal or ordered the removal of defense pleadings from chronological case summary in violation removal of defense pleadings from chronological case summary in violation of Indiana Supreme Court's administrative rules. Those pleadings include Frank's motion filed 9/18/23, Frank's memorandum filed 9/18/23, 3 affidavits, Warden Gallipew, Sergeant Jones, Sergeant Robinson filed 10/10/23, affidavit of the accused leaker, Mitch Westerman, and most recently an affidavit signed by defense investigator Suzanne Moeller, and incorporated a third request for transfer. By secreting pleadings from the docket without allowing the ACR rules, Rule 2A and Rule 4, Judge Gull allowed violations of public access. Because those acts have shielded documents, these actions demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1, compliance with the law, footnote 4, and Rule 2.2, impartiality and fairness, footnote 5. 13. Judge Gull engaged in additional violations to Access of Court Records Act. So it's the judge shall comply with the law, including the Code of Judicial Conduct. A judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. And see Supreme Court order dated 1/18/24 under cause number S3 or 23S-OR-311. So these are all the footnotes. Yes, and Judge Gull has a history of privating things or hiding things from the public. Now, this was the motion that the Supreme Court did not really do anything about because the judge kind of hurriedly put a lot of things in the public. But, I mean, she's got a long history of doing this with this particular case, and it's not looking good. Defendant Allen's original motion to disqualify Judge Gull was filed by Attorney Rossi on October 25, 2023. On October 27, 2023, the court issued an order noting that Attorney Rossi's withdrawal, albeit forced, from the case and was struck from the record substantive pleadings filed by Defendant Allen. Any authority the court had to strike the substantive pleadings from the record stemmed from the court's reversible error, terminating the attorney-client relationship between Defendant Allen and Rossi despite Defendant Allen's objection. The court conduct demonstrates the court's inability to remain impartial to Defendant Allen and further demonstrates that this court has engaged in judicial conduct that undermines all public confidence in the independence, integrity, and impartiality of the court in violation of Rule 1.2 of the CJC. Judge Gull failed to address her administrative duties. Attorney Baldwin submitted his first billing invoices on May 19, 2023. Baldwin's staff left several communication with Judge Gull's office concerning Judge Gull's failure to sign off on payment to Baldwin. As the months passed, those communications were basically ignored. The Carroll County advisors said they would pay the bill as soon as Judge Gull sent them an order, but they had not yet been sent an order. Finally, Baldwin personally sent an email to Judge Gull's staff essentially begging to be paid. Eventually, Baldwin's attorney bill from May 19, 2023 was paid in full on September 18, 2023, only a few days after Carroll County received an order from Judge Gull, almost 4 months to the day that the bill was tendered. Attorney Rossi submitted his first billing invoices on May 10, 2023. Said invoices were not satisfied until September 19, 2023. Since then, Judge Gull has failed and refused to authorize other payments of invoices submitted by Attorney Rossi in this cause. On October 4, 2023, Attorney Rossi submitted two separate invoices, one for his own services rendered, invoice number 2833 to Defendant Allen, and a second for administrative expenses reimbursement, invoice 2832. No action was taken on the invoices up to and including January 5th, 2024. On this day, Attorney Rossi reached out to Judge Gull's court staff through email and provided summaries of various outstanding invoices that had yet to be processed by the court. These included invoices from Attorney Baldwin, which were submitted in early December 2023, also yet to be processed. 4 days later, having received no response from the court, Attorney Rossi also sent a second email requesting a status update. The court staff response was that the 3-month-old invoices had been forwarded for review. 1 day later, Judge Gull's staff informed Attorney Rossi that several invoices had been approved and forwarded to the Carroll County clerk for payment. Several invoices were paid, including Attorney Baldwin's invoices submitted in early December. However, as of the filing of this motion, Attorney Rossi's invoices number 2832 and number 2833, submitted nearly 3.5 months ago, remain unpaid. Judge Gull's refusal to process the attorney's invoices in the normal course of business demonstrate a rational inference of bias against a defendant Allen, and further demonstrate her prejudicial behavior towards his defense team, even regarding administrative matters. If this woman is not removed, I don't know what to tell you. I can't. I can't with this woman. This woman is pissing me off. She is frosting my flakes. She's burning my biscuits. This is ridiculous. These men are working how many hours to go over how many terabytes of data? Even if you believe Richard Allen is the most guilty of guilty, these men are working their butts off, and she is not paying them, but has the nerve to call them grossly incompetent. Ma'am, don't throw stones. Furthermore, on August 8th, 2023, Allen's attorneys requested that the transcript from June 15th, 2023 hearing, in which the defense counsel requested Allen to be moved out of Westfield for reasons important to the defense, nearly 6 months have passed, and the defense has still not received a transcript from the June 15th, 2023 hearing. Judge Gull's failure to provide that transcript is another example of Judge Gull's contempt of the defense. It also provides a rational inference of bias and prejudice. Judge Gull failed to protect the accused. Defendant Allen's unique and unusually burdensome detention circumstances have been a concern of his defense team since he was shipped off to the state penitentiary only 1 month or so after his arrest. These concerns were immediately brought to the attention of the court by way of both in-chambers communications between Attorney Rossi and the court, as well as emails between Attorney Rossi and the court offering up reasonable solution to the problem. After the court declined to take precautionary actions, on April 5th, 2023, the defense team filed an emergency motion to modify the safekeeping order. The court's response to the emergency request was to set the matter for hearing on June 15th, 2023, a full 2.5 months after the emergency motion was filed. In the interim, Westfield inmate Robert Baston filed a pro se letter with the court corroborating some of the concerns regarding the detention circumstances surrounding defendant Allen. The defense subpoenaed inmate Baston to the June 15th, 2023 hearing. Attorney Rossi perfected service of the subpoena with the assistance of DOC staff attorney. However, on the morning of June 15th, 2023, Judge Francis Gull in chambers informed Attorneys Rossi and Baldwin that she had released Carroll County from executing the subpoena on inmate Baston due to his resistance to being transported by IDOC staff members. A hearing on the defense motion was then conducted, and thereafter the court issued an order or judgment of the court dated 7/19/2023, denying defense motion to move defendant Allen. In fact, suggested in the order that the, quote, evidence submitted did not support many, emphasis added, of the allegations advanced by defendant's counsel, end quote. In paperwork filed with the court on June 20th, 2023, but sealed by the judge until November 2023, and only unsealed after writing of a writ of mandamus against Judge Gull, it was revealed to the public that Judge Gull and or her staff chose to communicate with a state witness, Toby Lesenby, concerning inmate Baston's unwillingness to attend a hearing. Legally speaking, the witness has no choice but to appear, and Carroll County had no choice but to honor the subpoena and transport the witness. Prisoners all over the state are transported to hearings and trials they may not want to attend, even if their refusal to attend is out of fear that their testimony will put them in danger. The proper method to deal with the situation would have been for Judge Gull to alert both sides about the problem, then to conduct a hearing of the matter so that it's on the record, which the Court of Appeals would review later if needed. Instead, Judge Gull, either directly or through her staff, opted to leave the defense completely out of the equation and issue an ex parte, off the record ruling advising the Carroll County Sheriff's Department and Westfield Correctional Facility to leave the witness at Westville, thereby ignoring the valid subpoena prepared and properly served by the defense for a witness that was expected to support the defense assertions concerning Allen's treatment at Westfield. In summary, Judge Gull released the material defense witness from a properly served defense subpoena, then claimed that the defense team failed to meet its burden of proof, proving up the allegations in its emergency motion when it was Judge Gull that prevented a defense witness from testifying. Judge Gull's actions were prejudicial to Defendant Allen in that her actions usurped Defendant Allen's ability to prosecute his own emergency motion, which is otherwise known as a refusal of compulsory process. Judge Gull's behavior exhibits a rational inference of bias and prejudice against Allen and his attorneys. I mean, how much more can this woman be a mega see you next Tuesday? Furthermore, her actions violate Rule 2.3 of at this point, it'd be easier to go over the rules she didn't violate. Quicker. Rule 2.3 of the CJC. Judge Gull's continued and ongoing failure to protect the accused. Judge Gull has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused. On 2 different occasions, the court has been asked to order the removal of Richard Allen from the Westville Correctional Facility and place him in a less restrictive and healthier environment. As he is a pretrial detainee, this court has denied both attempts. At times following these denials, the court has taken the position that the allegations offered up by defense counsel were untrue. Most notably, the court accused Attorney Rossi of misrepresenting truths about his detention circumstances and used this as support for Judge Gull's finding the defense counsel engaged in gross negligence in their representation of Defendant Allen. Mr. Allen's replacement attorneys filed a third motion requesting his transfer in early January of 2024. The allegations in the motion addressed ongoing connections between Odinites employed by the IDOC who had continued to be in contact with Mr. Allen. Former counsel Scremin actually offered up a photo of one guard who was so bold as to tattoo an Odinite symbol on his face while knowing that his Odinite connections had previously been called into question by the defense in a formal pleading. In addition, there are new claims that Mr. Allen continues to be detained, i.e. shackled like Hannibal Lecter, unnecessarily, and has now been moved, apparently without any judicial involvement, to a facility some 233 miles from his replacement counsel, Attorneys Scremin and Labrado. The court continues to take no action to protect Mr. Allen. This is not an adversarial matter or issue. The state should be an uninterested party in this matter. There is no need for the introduction of evidence in support of these claims. The court has absolute jurisdiction of Mr. Allen's detention circumstances. It would be entirely appropriate for the court to err on the side of caution and engage in remedial measures to ensure Mr. Allen is being housed under humane circumstances for a pre-trial detainee. It would be entirely appropriate for the court to order the detention of Mr. Allen in a facility close or near his court-appointed attorneys so they would have simple convenience of communicating with him in person under reasonable conditions without the necessity of lengthy sojourns each and every time they desire to meet with Mr. Allen to prepare his defense. Attorney Rossi had even arranged for Cass County Jail, literally a 2-minute walk from Mr. Attorney Rossi's office to keep Richard Allen in pre-trial detention. This request was denied as Judge Gull sided with Carroll County Sheriff's Department due to its confusing claim that the sheriff would have difficulty transporting Rick Allen's 20 minutes from Loganport to Delphi, when it was taking much longer than that to transport Allen from Westville to Delphi. The court's refusal to intervene is prejudicial to Mr. Allen and in violation of Rule 2.3 of the CJC. The court's refusal to intervene violates Mr. Allen's Sixth Amendment right to present a defense and runs afoul of his due process rights under the state and federal constitutions. Judge Gull's failure to make common sense measures to move Richard Allen out of Westfield, especially after it was proven that he was guarded by practicing paganist, Odinist, parentheses, when evidence and allegations exist that Odinists were involved in the murders, provides a rational inference of bias against Mr. Allen. Judge Gull has treated the prosecution more favorably than defense counsel. Through the entirety of the Franks memorandum, the defense detailed and provided evidence exposing false and/or contradictory sworn testimony by law enforcement and even withholding of exculpatory evidence by the prosecution. And then this is where Rossi was telling him that he basically got Cass County local jail to basically make a deal that they were going to hold Richard Allen if the court would agree. So this exchange occurred in an email from Attorney Rossi to Judge Gull, Prosecutor McClelland, and Attorney Baldwin, as well as Cass County Sheriff Schroeder on February 8th, 2023 at 11:31 a.m. So all the way back in 2023, February, I mean, he had a plan set up to where he could have been in Cass County. Richard Allen could have been in Cass County local jail. I'm sure they have, a protected, prisoner sort of area. Judge Gull did not have to read too far into the Franks memo to find these intentional acts on the part of the state alleged by the defense as many of the most egregious intentional behavior of the state is referenced in the first 25 pages. The state of Indiana was continuing to provide large quantities of discovery even into October, nearly 10 months after Rossi and Baldwin entered their appearance, causing Rossi and Baldwin to seek a discovery deadline. Despite the state's intentional behavior, including the non-disclosure of exculpatory evidence, Judge Gull has focused her ire on Rick Allen's counsel for what she claimed was gross negligence. For example, Nick McClelland, I call him Miami Vice, you'll have to see the hair, was in possession of highly exculpatory document prepared by Officer Todd Click, own lawyer, in which Click alerted McClelland that Click was concerned that McClelland had not been informed about Click's involvement investigating a group of men whom he believed were involved in the murders. Evidence that 3 parties involved in Odinism had murdered the girls. McClelland held on to that highly exculpatory document for nearly 4 months without turning it over to the defense. McClelland's failure to turn over the exculpatory documents also prevented the defense from questioning investigators about the exculpatory information during the defense depositions in early August. This failure on the part of prosecutor will require additional depositions and prolong the discovery process. McClelland's failure to turn over exculpatory documents is accurately detailed in the Franks memorandum. Despite these truths, Judge Gull has never, not one time, chastised McClelland for these wrongs. Judge Gull never told McClelland that his behavior appears intentional, or grossly intentional, or at least grossly negligent. Judge Gull never indicated and it said that the Click document was not disclosed to Allen's defense team until September 2023. Judge Gull never indicated her belief that McClelland should be replaced, nor did she ambush him in an in-chambers meeting after allowing cameras in the courtroom to tell him that she was kicking him off the case. In fact, on page 16 of the transcript that Indiana Supreme Court ordered Judge Gull to release, Judge Gull even states, quote, "I am not accusing the state of gross incompetence and negligence. I am finding gross incompetence and negligence with you. The fact that Gull has solely focused her ire on perceived belief that Rossi and Baldwin are grossly negligent and incompetent, while not addressing the prosecution's provable discovery issues, provides a rational inference of bias or prejudice against Richard Allen and his defense team." Judge Gull engaged in unacceptable extrajudicial activities. On July 9th, 2023, someone who is believed to be Judge Gull's then daughter-in-law published an entry on her Facebook page, her own Facebook page, stating the following, quote, "What an honor was for the girls to play in the Abby and Libby Memorial Tournament. What a greater honor it was that Abby and Libby's grandparents presented our girls with the championship finalist rings." End quote. In spite of being the presiding judge in this case, at the time the message was posted, Judge Gull made the choice to publicly comment on the post with a simple congratulations. While this post might appear to be innocuous comment to Richard Allen's counsel, it raises fair questions about whether or not the rational inference of bias and prejudice exists. 9. The Facebook post is not included herein as it contains photos and names which need not be made part of the record. A copy of the post can be provided at a later hearing. So I'm guessing it has some kids in it or something. And, way to be a class act and not bring kids into it. So that's, better. As the presumable relatives of Judge Gull who were mentioned in this post will likely see Judge Gull from time to time, communicate with Judge Gull, and have opinions concerning the murders of Abby and Libby. And Judge Gull must know that her relatives may have been emotionally impacted by their involvement in the softball tournament, especially from interacting with Abby and Libby's grandparents. Yet, knowing all of this and knowing that Judge Gull will be challenged with resolving evidentiary and procedural disputes in the case, she chose to comment on the post. In 2013, the American Bar Association, ABA, issued Formal Opinion 462 entitled Judges' Use of Electronic Social Networking Media. While the ABA acknowledged that electronic social networking media can be beneficial, judges were cautioned to be conscientious of the way their online relationships will appear to others. Under the Model Code of Judicial Conduct, judges are obligated to, quote, "maintain the dignity of judicial office at all time and avoid both impropriety and the appearance of impropriety in their professional and personal lives. Judges must therefore be very cautious in their use of electronic social media, as online communications and friendships taken out of context can create the appearance of bias or impropriety, thereby undermining public confidence in the judiciary." 3.3 ALR 7th Article 9, originally published in 2017, publicly commenting on a post concerning a softball tournament that honors the victims in this case, provides evidence of rational inference of bias. Holy fazoli's, guys. It just goes on and on. I mean, she's like one steaming pile of bias. In fact, that might be a thumbnail. Timing of judicial bias, prejudice, and lack of impartiality. RPC 2.4C2 requires that a good cause be shown when any move-in for a change of judge cannot meet 30-day timing requirement referenced in subsection 1 of the rule. Defendant Allen asserts that the first time Judge Gull's bias was cemented in the minds of the defense, demonstrating her bias, prejudice, and lack of impartiality, occurred during the phone call between Prosecutor McClelland, attorneys Rossi's, Baldwin, and the court. This phone call occurred on October 10, 2023. During this call, Prosecutor McClelland made a fleeting reference to the potential disqualification of attorneys Rossi and Baldwin. With very little hesitation, Judge Gull suggested the court was leaning toward disqualification and thereafter ordered the parties to appear in her Allen County courtroom on October 19th, 2023. It was at this hearing that the court staged a premeditated severing of both Attorney Rossi and Baldwin as chosen lawyers of Richard Allen, leading to contentious and very public litigation. The claims contained herein, some of which occurred prior to the October 10th phone call, are believed by Richard Allen to be pieces of a puzzle, the totality of which illustrates the court's bias, prejudice, lack of impartiality toward Richard Allen. Some of the factual matters that show rational inference of bias occurred before October 10th, 2023. The defense had hoped that some of Judge Gull's questionable behavior that predated October 2023 were not signs of bias. However, when placed into context, Judge Gull's actions predating October 10th, 2023, are now viewed as evidence of a continued pattern of bias, such as Judge Gull's failure to pay defense attorney Rossi's and Baldwin in a timely fashion and Judge Gull's continued failure to protect Richard Allen. Obviously, neither attorneys Rossi or Baldwin had the authority to file any pleadings in the case after October 31st, 2023, due to Judge Gull's forced removal of Allen's chosen lawyers. Therefore, Baldwin and Rossi could not file their motion for change of judge until after the Supreme Court placed Rossi and Baldwin back on the case. It is from this set of circumstances that Richard Allen asserts his claim in support of his motion for a change of judge from Francis C. Gull. Holy fazoli's, guys. If this guy doesn't get... Look, as I have said from the beginning, and I think we need this... Yes, just a normal nuclear volcano on top of a dumpster fire, this case, this woman, this judge. If they don't get a new lawyer or a new judge, then this case is FUBAR beyond all belief. And I suggest you go look up what FUBAR means. Unless you're a child, then why are you watching me? Go do your homework. But yeah, definitely, this really opens my eyes to a lot of shenanigans that she was doing behind the scenes. The fact that she wasn't even approving these guys' pay slips, I mean, you know, what a petty biatch, okay? Can we be honest? This woman should never be a judge. I don't know if this is a pattern that she's had through all of her cases, but this is beyond ridiculous. And as I have said from the beginning, if they can prove that Richard Allen is the guiltiest of guilty, then send him to a dark hole once we have all of the evidence, and he can go directly to Snake Island. I have no problem with that. But what I see right here is Judge Goodfellas, you know, trying to pull some mafiosa, you know, head Karen BS that is in no way justice. So I will see you guys in a little bit. I'm going to go make a thumbnail for this and then put it up because holy smokes, this was a long one. Have a great day. Be kind to yourself. Be kind to others. And I will see you in a little bit for Newsy News. Holy mazzolis, that was a long one.